Hi, everybody. It's Michael Levitas from JurisQ.com, and I welcome back Irina Yadgarova, estate planning attorney, elder law attorney. Irina, welcome back.
Hello, thank you so much for having me again.
Thank you. Irina, of course, we discuss important matters that have to do with estate planning, with Medicaid trusts. And when people think about trust and estates, they think, oh, I'll deal with it later when I'm already 65. Right now, I'm a bit younger. I don't want to worry about it. I don't want to think about it. But we know that is not the case. You have to start preparing earlier. So I want to talk to you about two critical stages in your life when it's time to think about estate planning for yourself or maybe for your loved ones. Maybe you want to think about your parents, how that could affect them. So let's start off with a bit younger people, right? When I say younger, I don't mean teenagers or early 20s in college. I'm saying when you're already professional, you have some kind of business, start making a little bit of money, maybe you have a family, and this is when it's time to start thinking and planning. So can you tell us, Irina, at that stage of your life, what you should think about and consider in estate planning and why?
Right. Yeah, absolutely. I think you said it really well. I think for most people, I would say late 20s, early 30s, deeper into your 30s and 40s, you have a career, you have a family, you have young kids. So for the vast majority, and I see more and more younger couples coming in, which is great. I think people are paying attention. Maybe it was with all the deaths we've encountered during COVID and things like that. People have been confronted with our own mortality, right? Things that can happen to those around us, our loved ones. So it's important to start, some sort of planning, and everybody's situation is a little bit different. But for those who have children, right, you want to make sure to have your minors be taken care of in terms of who is going to be their legal guardian. Do you want a different person managing their finances? Do you know, are you and your spouse or the parent of the child on the same page? Because you can really direct through your will the courts to honor the decision that you made together with the other parent of who would be the legal guardian and the financial guardian in case, God forbid, you and the other parent are no longer around. A lot of people vacation together. A lot of us take vacations, and I see a lot of people coming to me around that time to try to, make sure that they're protected against that risk.
Of course.
And certainly individuals who are young but have properties in multiple jurisdictions, that's very important to think about revocable living trust, where you retain maximum control but avoid any kind of probate process. So if you have properties or a vacation home upstate or in multiple jurisdictions, very important to think about that. And I just want to say,
otherwise you have to go, Irina, otherwise you have to go through court in every state, correct? Which could be very cumbersome and expensive.
Yeah, your children or whomever will be taking care of the estate would have to hire attorneys licensed in those jurisdictions and go to the courts in those jurisdictions for what's called the ancillary probate or ancillary administration.
I see.
So definitely want to try to plan ahead around that. But for the younger ones, you said, certainly there's a lot of wealth being amassed by young individuals these days. And that's another reason to consider early estate planning, to try to get ahead of some tax planning and, again, multiple jurisdictions issues. So, but otherwise, for typical couples, I would say it's to make sure you're taking care of the basics, that your young children, that you're protecting for, the guardianship risk need that may arise. And of course, the basic staples of a simple estate plan is the will, right, where we take care of the guardianship, the powers of attorney, and the healthcare proxies. And
yeah, I mean, those are all very important. What about another aspect of estate planning, which is asset protection? As you start generating wealth, you want to protect that wealth against any incidentals like a possible lawsuit, judgment. It's possible to act early, correct? And put
you
your
have
assets
to act early.
in trust.
Right, you have to act early, because remember, if you're an individual who is high risk, like a lot of physicians maybe have a higher risk, they typically have the malpractice insurance coverage, but they're the ones who I see call myself and other estate planning attorneys to try to hedge against risk. So once a person has already incurred a creditor or has been aware that they're going to be called upon in a lawsuit or a collections action, it's too late to do any
Yeah.
kind of real asset protection. It would be subject to reversal by the court for fraud. So you
Right.
have to definitely step ahead of the game. So if you know you're either at a higher risk or your assets are growing at a rapid pace and you want to ensure protection of those assets, you're kind of looking at it in those buckets of what kind of property am I seeking to protect against what type of creditor, and does it make sense? Because protecting assets usually goes hand in hand with relinquishing some control over those assets.
Okay.
So asset protection is very common and recommended 55 and up. And then if you're younger, we look at like various facets. Everybody's kind of an individual case when you're younger.
Okay, Irina, you just mentioned another critical phase in your life when you have to start seriously considering estate planning, which is 55 plus. Why this magic number 55, Irina?
Yeah, so 55 is a magic number for a few reasons. The main reason is because when we're engaging in elder law planning and Medicaid planning, if a person has a crisis and ends up with a stroke or some health condition that necessitates them to go on either Medicaid or a long-term care healthcare facility, 55 is the magic number when HRA, which is the Medicaid agency that handles Medicaid in the 5 boroughs.
Okay.
This is the time where New York State Medicaid, if you're on New York State Medicaid and you're 55 and up, again, whether by choice or by default because there was a health crisis, they will keep a track of every single penny, dollar for dollar, for anything that they've incurred on your healthcare, and they are mandated under New York State law to recover it from your estate. So for the last 10 years of your life, 55 and up, any dollar that they spent on any medical care, including prescription drugs, including medical supplies, even the medical gloves or whatever that was dispensed under Medicaid, everything will be recouped. And what is the recoupment? Is generally through your house, because that would typically be your only asset once you're allowed to get on Medicaid, because the crisis either forced you to spend all your money or you didn't have any and you ended up on Medicaid either way.
Irina, this is such an important point that I really want to emphasize again. You may qualify to get Medicaid, Medicare, you may be okay with you covering your medical expenses. However, correct me if I'm wrong, your children, whoever you want to leave your estate to, from them, the costs could be deducted. So you think you're leaving the house free and clear, maybe even have no mortgage in it, you're leaving it to your kids when you're gone. In reality, the government is going to come in and take a portion to recoup their expenses. And there's a mechanism that you employ, that estate attorneys employ to legally go around it and protect that asset, the most important asset you have, which is your house, correct?
Right. And I just want to say one thing that I found very interesting. I had a client a number of years ago. He had a will, and he, for some reason, I don't know how many viewers out there are under this impression as well. He was convinced that because his mother had a will, that her co-op would be like fully his upon her demise. She really just owned a co-op. She didn't have any other assets. And she was on Medicaid. He went to an estate planning attorney and they just did a will. So maybe they didn't consider the Medicaid implications. Maybe it wasn't even like a subject that was raised. But he was so upset that during this probate process, Medicaid put a collection on that they had to recover against that co-op. And they took a big chunk out of it. He was barely left with anything. But he was just so upset that he went to, he did what he thought he had to do. He got the will, but the will has no asset protection element to it. So be very careful when it comes to working with somebody who does elder law when you're 55 and up. You don't want to miss those planning points.
These stories, they're mind-boggling. When you go to a professional that you think you can trust, because this is the reason why you go to an attorney, to get professional advice, and you get bad advice, or the attorney does not omits what he or she should tell you. We should do a whole video on busting myths in estate planning, and when you should get second opinion, even after going to an estate attorney.
I think in New York, if you're 55 and up, I don't think you can just go to an estate. I think you have to have an elder and estate attorney looking at it, because
that's right.
If you're just dealing with taxes or high net worth estates, you may not be like, if you're not dealing with the Medicaid world, you can't really be a true estate professional when you're 55 and up here, because it's so entangled and enmeshed. that you have to, you have to raise these points and think about them.
Okay, Irina, let's say somebody was already retirement age, 65, 70. They didn't have an opportunity to watch our videos. And this is why we do these things, is to educate the public. We give free advice right now, general advice, of course, to educate the public so they know what's out there. Because these are very intricate, complex areas of law, so you should know. Okay, somebody didn't have an opportunity. They went their whole life without estate planning. Now they're 65, 70. Is it too late, or can still be something be done for them?
Yeah, no, absolutely. It's not too late. It's not too late. And a lot of my clients are actually in their 70s and 80s. And the older that a person gets, the more difficult it is to do full asset protection. Because again, if you recall, there's these, 5-year look back for,
Okay.
nursing home Medicaid eligibility upon a transfer. So you have to take action, as early and as practicably as possible. The only time that it's really too late is when a person, it could be even a younger person, but it's when a person has some sort of a health condition that renders them mentally incapacitated, and they can no longer direct the signing of a power of attorney to act for them. So in that case, it becomes too late for this to be simple. You would have to go through a guardianship process because that person themselves no longer has capacity. Usually that's, deep into our old age, right? But I see this often with young men, young women, again, with stroke or something like that. And that's why it's important for even those younger, just to come back like full circle here, for the young couples, it's so important to have the durable powers of attorney, because your spouse does not have the right to speak for you financially. Even if you're, you have a joint account, that's great. You can certainly sign checks there. But what about, selling your home or applying for Medicaid or, whatever it may be. And so that's really important to have that durable power of attorney in place.
Perfect. Irina, thank you so much for your advice, because people don't want to think about it. It's a little bit unpleasant. People want to plan their vacations, look for homes, nice new fancy cars. They don't want to think about what happens when they're retired or after they're gone. But guess what? It's a necessary, it's a part of our life. It is very important to consult an attorney like Irina Yadgarova early, so you know your options. You can plan your whole life. As you grow in your career, in your business, or whatever you're doing, you have to implement steps to protect the assets you accumulate. Also, very important to think about your parents. I mean, right? Maybe your parents haven't done any estate planning, and as we discussed with Irina, down the road, they think they're leaving the house for you, but the government can take a portion away. So it's important to think for your parents.
I tell the parents, tell the kids to pay for the planning, because it's really for their benefit, most of it.
So kids, take your parents by the hand, bring them to Irina Yadgarova, or parents, take your kids, also bring them to Irina Yadgarova, get advice. The number is on the bottom of the screen. Irina, thank you so much. We're going to see you soon, Michael, with more questions and more answers on elder and estate planning law. Thank you so much.
Sounds good. Thank you. Be well. Bye.
Bye-bye.